Pasha Paroh Y Net 7. Thank you for tuning. Give me 1 second. All right, so what we're gonna be going over today is exhaustion. All right, so if you got the Civil Resource Manual or if you're online with it, go ahead and pull it up. You know, here's the online version, and what we want to look at today is number 34, exhaustion of administrative remedies. Now, before I get into that, I just kind of want to ask you guys some questions, okay? 3 questions real quick. So the questions I have is like, when we're going over this, I want you to think about, could this be the reason or could this be why, right? However you want to phrase it to yourself. Could this be why, or could this be part of the reason, you know, however you want to say it to yourself. So could this be why people are in situations where they don't like, you know, what's being done to them at their job, and you wonder why every time you talk to your supervisor or they talk to their boss, quote unquote, nothing changes, nothing happens, and it's kind of like they're left with, well, either you gonna keep coming back or not, right? Question 2, could this be why certain groups of people, certain mindsets will tell you, don't argue something like a ticket, a traffic ticket, for your entertainment purposes only. Of course, you know, this is only entertainment. I'm not a legal professional. I'm not giving you any advice. I'm just being a comedian, whether you laugh or not, for your entertainment. So could this be why you shouldn't even waste your time arguing something as trivial as a traffic ticket with a cop? You know, you may want to seek remedy at the next level. Something more heavier, like, could this be why people feel like they haven't received, like, let's say black people who you call black, right, would say they haven't received reparations? Could it be because they have an exhausted administrative remedy? And then with those questions on the table at different levels and different conversations of magnitude, it gives you an opportunity to say, well, hey, wait a minute, what would be the remedy that we might be missing, right? So what is 34 talking about? 34 is discussing entitle exhaustion of administrative remedies. Okay? Exhaustion of administrative remedies. So it says here, generally, the plaintiff suing a government officer, right? The plaintiff suing a government officer may not obtain judicial relief if he has not first exhausted his or her administrative remedies. And it gives you a few cases there. C. Allen versus Grand Central Aircraft Company. That's a pretty interesting case dealing with the National Wage Agency or outfit or whatever, the one that basically was setting and establishing the wages. I was gonna show you that route. I chose the second portion of it here to cover with you today, and maybe we'll revisit that in the near future. So Generally, the plaintiff suing a government officer may not obtain judicial relief if he has not first exhausted his or her administrative remedies. All right. Then it goes on to say exhaustion is also required in Federal Tort Claims Act suits. All right. Per 28 USC subsection 2675A, Privacy Act suits, etc., etc. In suits challenging adverse personnel acts, not personal, but personnel actions, and in many other contexts, right? So then it goes here, Darby versus Narrows, okay, which is what I'm going to show you today. We're going to review today for your entertainment. Holds that under the Administrative Procedure Act 5 USC 704, a person aggrieved by an agency action can seek judicial review of the action without exhausting an available administrative appeal unless agencies' regulations provide both that the administrative appeal must be taken and that during the pendency of the administrative appeal, the agency action shall be inoperative. I know that's some verbiage, right? That's some verbiage. And that's what the key is here. That's what the magic is. The magic is in the wordplay. So let's look at what these words actually are referring to here. Let's look at administrative first of all. Okay? Let me get that on the screen. Give me a second. All right, so first of all, exhaustion, right? It's not really in, I'm not going to say it's not in the law dictionary. However, let's just say it's not in Black's Law Dictionary, the 3rd edition. And let me see here. Let me see if it's in, because I have the etymology for it for you today, which makes sense. Let me just check one last thing here real quick while it's on my mind. Hold on one second. Okay, so in the dictionary of legal terms, okay, so the etymology is to use up, consume, exhaustion. That's the 1533 verb, right? Which was first, and then the noun became fatigue, loss of strength. All right, a drawing off. So that's why this is another cool book here I just got a little while ago. So exhaustion of remedies, it says, is a judicial policy or statutory requirement that certain administrative or non-federal judicial remedies be pursued by a litigant before a state or federal court will consider the controversy. Okay? And then it actually has in here, it says for exhaustion of administrative remedies, all right, as we break this down for you, because we're going to go over the case. I want you to know what you're listening to and why this is important. So the doctrine of all courts, so exhaustion of administrative remedies here, as defined as the doctrine of all courts adopted either as judicial policy or by statutory directive, that the courts will not interfere with or review an administrative decision or process until the available administrative channels of review have been attempted. This requirement stems from the usual requirement that courts review only final administrative actions. The doctrine avoids piecemeal interruption of administrative processes, conserves scarce judicial resources, and ensures that the expertise of administrative agencies will be fully employed. In some extreme cases where irreparable harm to public or private interests, may be caused by honoring the doctrine, it will be held inapplicable. Okay? So, let's convert these words to get the complete comprehension. Okay? So exhaust, to use up, consume, right? And you just heard that in that language. Now, if we go and look at the word administrative, right? It's pertaining to, this is from the Black's Law Dictionary, pertaining to administration, particularly having the character of executive or ministerial action. All right? Character, having the character of. In this sense, administrative functions or acts are distinguished from such acts as are judicial. Several court cases for review there to confirm that. Now, what I thought was interesting also is that near the end, and we'll cover this shortly too, it says, and of that definition, of that explanation, it says an administrative act concerns daily affairs as distinguished from permanent matters. And that's where we just heard earlier where it's speaking about it has to wait for things to become final. Okay? The courts have to wait for it to become final. All right, so now if you look at it, because it'll say see administration, we can go check out what administration is real quick to really get in depth with the communication here. So administration in public law, the administration of government means the practical management and direction of the executive department or the public machinery or functions or of the operations of the various organs of the sovereign. Okay? So the term administration is also conveniently applied to the whole class of public functionaries or those in charge of the management of the executive department. Okay? You with me? All right. So one last word to look into here, right? And then we'll put it all together in a long spelling, as I call it. Is remedy. What is a remedy? A remedy is the means by which a right is enforced or the violation of a right is prevented, redressed, or compensated. And this breaks it down that remedies come in 4 kinds, okay? And those 4 kinds of remedies basically are by act of the party, by operation of law, by agreement between the parties, and then the by judicial remedy. Okay, so when you look at all that together, what we get in the meaning of exhaustion of administrative remedies, what we get is you must use up the practical management and direction of the executive departments first, allowing their character of executive or administrative action to enforce a right or prevent a violation of a right, as well as redress or compensate. So you have to allow that first. But what are the limitations of that? What is too much? Because there were measures put in place for the people not to be caught into a series of hoops that you have to jump through forever before you could take it to court. All right. So what we're going to look at today is Darby versus Cisneros. Okay. We're going to cover a very little bit of People versus Graham, but we're going to pretty much focus on Darby versus Cisneros, 509 U.S. 137, 1993. And I chose this one because it's a more modern case, and for those that enjoy watching the contest, so to speak, stay tuned. In the latter part of this, we're going to, or let's say, post our review here. We're going to go ahead and watch or listen to rather those arguments. Okay, so stay tuned for that. All right. Let me get you this here real quick. All right, so here goes Darby versus Cisneros. Let me know. So basically, here's what happened. Right, in a consolidated appeal from decisions by the Department of Housing (HUD), okay, to initiate administrative sanctions against petitioners, an administrative law judge. Okay, now some other things we could cover real quick, right? So an administrative law is law created, right? Law created by administrative agencies by way of rules, regulations, orders, and decisions. Okay, so when you're the agency kind of gets to make its own rules. Your workplace gets to make its own rules, right? And then everybody under that gets to follow those. So anyway, administrative law is law created by administrative agencies by way of rules, regulations, orders, and decisions. And then on a ALJ, which we're going to talk about here, so you know what that is. An administrative law judge is the presiding officer at an administrative hearing, okay, and whose power is essentially one of recommendation. In the federal system, per legal terms, explanation, right? In the federal system, he or she can administer oaths, issue subpoenas, rule on evidence, take dispositions, make or recommend decisions which can be appealed to the federal agency. Keep that in mind. For which he or she hears cases and then to court of law. Okay? So you got the order, right? You got to start here on your level, go through the staircase or the ladder within the agency itself, or do you? And then go to court with it. I guess it's not a or do you, it's a matter of how long do you have to climb the ladder before you could deem a decision final. And that's what we're going to talk about today, all right? So think about what things you may be going through in your life. People having cases maybe with CPS, or this agency over here or that agency over there, right? So think about how long you gotta keep arguing before you can deem their decision final, because the agency itself is not the last or final opportunity for justice, so to speak, right? Okay, so let's get into it. Back at it. In a consolidated appeal from decisions by the Department of Housing and Urban Development, HUD, to initiate administrative sanctions against petitioners, an administrative law judge concluded that petitioners should be debarred from participating in federal programs for 18 months. Okay, so like if you were flipping houses, right? If you were flipping houses, this is an example for your entertainment purposes. You may be accessing opportunities through HUD, and if they were to sanction you and say, hey, you can't participate for 18 months. All right, that kind of gives you an idea of the nature of this case. Okay, so let's look into it. Under HUD regulations, the ALJ's determination, in quotations here and abbreviated, shall be final unless the secretary, within 30 days of receipt of request, decides as a matter of discretion to review the ALJ's finding. And they give you their location of that authority. It's 24 CFR subsection 22 314C. All right. Now, in this particular case, neither party sought further administrative review. Petitioners filed suit in district court seeking an injunction, okay, and declaration that the sanctions were not in accordance with law within the meaning of Administrative Procedure Act, APA. So the respondents moved to dismiss the claimant on the ground that petitioners, by foregoing the option to seek review by the secretary, had failed to exhaust their administrative remedies. All right, so that's the two sides of the argument, and I'm really excited because if you're on my Facebook, you know I showed you this book as well as this book, right? Because I just got them in like a week ago. So this one is really dope. Let me put it on the big screen for you. So this one's really dope. It's called The Tools of Argument: How the Best Lawyers Think, Argue, and Win. And there's a whole formula, right, to these arguments or debates or whatever you want to call. And learning this stuff will help you not only process how to structure an argument for yourself in court, it'll also help you in life, as long as like your relationships, your business deals, all kinds of stuff, right? So great book, and learning what you're actually listening to in structure just makes it that much easier for you to see the plays that's going on, etc., etc., etc. It's like when you're watching the game with someone that don't know the game, and you got to explain why they doing this, why they doing that. That's the difference this book makes in any type of argument situation or debate, or any time that you're trying to make your case or point. So great resource. Pick it up, look into it, read it, let me know, thank me later. All right, Pasha Paroh, we're gonna keep it moving. So with this, right, so with this, what they were saying was they were claiming, the respondents moved to dismiss the claimant on the ground that their on the ground that the petitioners, by foregoing the options, basically because they didn't seek, going back up here, you see right here, say here, the administrative law judge's determination shall be final unless the secretary, within 30 days of receipt of a request, decides a matter of discretion to review. And this is why spending time, I don't care if it takes you 5 years to really get an understanding of what the words mean, okay? And what someone is actually saying to you, instead of you allowing your emotions to control you and make you feel like you know what they're talking about, is super critical. And this is why so many people get mad when people take their time to communicate on such levels, because you got to apply thought. But I mean, that's what's going to keep you protected. You know, everybody's talking about smacking somebody, fighting somebody, gunning somebody down, right? But you know, those who I made this quote a day or two ago, after I was thinking, you know, I'd be having thoughts and I just put a quote down. I mean, one day they may be priceless to humanity, you know what I'm saying? So you never want to lose your thought. But I was saying, basically, those who are waiting on a bullet to recognize a battle have already lost the war. You see what I'm saying? You want to fight somebody. You want to, or not you, but they want to fight somebody. They want to smack somebody. They want to gun somebody down. But the battle that everybody's losing is right here in these words that you speak every day, that you sign in contracts, that you sign in leases, you sign in rental agreements, you sign in car loans, you sign in mortgages, right? You signing up for tuition, you signing promise to pay, right? And you don't know what none of these words mean. Exhaustion of administrative remedies. All right, let's get back with it. So what they're saying is that because of this statement here, the LJ's determination shall be final unless the secretary within 30 days of receipt request decides as a matter of discretion to review it. All right. So then it comes down here and it says that neither party sought further administrative review. So the one side is saying, hey, you guys didn't say anything else after that. It's done. Or you were supposed to allow the secretary to review it within 30 days. Or, give the secretary 30 days after they receive it to review it. Power of words. So the respondents moved to dismiss the claimant on that ground, saying that by foregoing the option to seek review by the secretary, they had failed to exhaust their administrative remedies. The court now this is the first court. The first court denied the motion and granted summary judgment to petitioners on the merits of the case. So they said after they lost, right? After the respondents lost, they said, no, we're gonna take it to the Court of Appeals. We're gonna appeal it. Take it to the appellate court. So they went to the Court of Appeals. The Court of Appeals reversed the first decision, holding that the district court had erred in denying the motion to dismiss. And error just mean, they made an error. All right? So this is how I got to the Supreme Court. Okay? And, from the administrative purpose or allowing them time to process it, it makes sense. Because if you look at it from what you think a business's standpoint, like I know we got the fans in the house that say the United States is a business, a corporation, and we covered the agencies are part of that hierarchy, right? So that would make sense if you look at it as a goal of every super successful business is to sell all of their products to you before allowing you to leave. And if you can get this entrapment, if you can get this on a contract, even better, right? And this is why you had this set up. So this what we're going to see in what's known as 704, Title 5, United States Code, subsection 704, is it provides the remedy so that you don't get caught up in a forever jumping through hoops on the agency level. Okay? So let's take a look at this. Because what it's saying is, what held is that the federal courts do not, and here, let's jump over here real quick. Because one cool thing to look at is here goes Title 5 U.S. Code 704. Let me show that to you here. So the agency action made reviewable by statute and final agency action, for which there is no other adequate remedy in a court are subject to judicial review. All right? So remember, agency action, remember we talked about the administrative law judge, hearings on that level is still called, you could consider that a court as well, right? All right. So agency actions made reviewable by statute and final agency action, because it has to be final, then it can be reviewed, right? That's what they say. So for which there is no other adequate remedy in a court are subject to judicial review. The next sentence follows that saying a preliminary, procedural, or intermediate agency action or ruling not directly reviewable is subject to review on the review of the final agency action, except as otherwise expressly required by statute. Agency action otherwise final is final for the purpose of this section, whether or not there has been presented a determined and application for declaratory order for any form of reconsideration, or unless the agency otherwise requires the rule or by rule and provides that the action meanwhile is inoperative for an appeal to superior agency authority. So this right here, the second line, okay, a preliminary, procedural, or intermediate agency action or ruling not directly reviewable is subject to review on the review of the final agency action. This is where, if we go back to the Black's Law definition of administration or administrative, let me see which one it was. Yeah. So administrative down here at the bottom, after it says an administrative act concerns daily affairs as distinguished from permanent matters. Okay? That means that it has to be, it's talking about the administrative level is concerned with the day-to-day, but once it becomes a final, that's when, you have that access that it can be requested judicial review. Okay? But the key part I wanted to point out here is that this is where we get into it's a See People versus Graham. And the reason why I think I like what I gathered from there as far as what we're going to go over today with People versus Graham, it goes back to Title 5 USC subsection 704 in that second line. Let me get that on the screen for you so you can see it. All right, there you go. So the second line there where it says a preliminary, procedural, or intermediate agency action or ruling. Because see, it takes actions to come up with a ruling, right? They're going to apply certain actions. So a preliminary, procedural, or intermediate agency action or ruling not directly reviewable is subject to review on the review of the final agency action. So this is the exact line that I think, for your entertainment purposes, that I think changed the outcome of this right here, People versus Graham. So without taking you through the whole case, feel free to look this up on your own. Basically, in the beginning, here's the rundown. Rick Mitchell Graham appeals a judgment following a jury trial, which he was convicted of second-degree robbery. Okay, he was sentenced to prison for the term prescribed by law. All right, so that's how I got to the appeal. And what happened was, in the appeal, what happened was the court, it was found that, okay, so now it was final. Let's excuse me for a second there. Let's stay with the the reason I'm showing this to you. So he was convicted of second-degree robbery, right? So that was the final, the finality of the administrative process, right, on the jury trial. You got that? You follow how that's looking? Okay. And he was wound up being sentenced to prison for a term of whatever was prescribed by law. So now that was made final, all of the actions, okay, go back to 704, right? All of the preliminaries, the procedural, because see, they couldn't say nothing at this time about it because it was like, okay, this is our ruling, boom, this is it, that's final, you're going to jail, buddy, right? So now that it's been made final, the whole entire process can be reviewed of how they arrived at that decision. And this is one of the benefits of the next level, or appealing a case. Okay, so in this situation, what we're looking at is all of the preliminaries, all of the procedural, or all of the intermediate agency actions. And I'm going to put another word in there, and or the ruling, which prior to would not be directly reviewable, is subject to review on the review of the final agency action. So see, during the case, it's like, again, going back to those questions, right, that I asked you in the beginning. Could this be why when some of you talk to your bosses or your supervisors or your whoever, nothing changes? Could this be why you could argue all day about the ticket with the cop, and the cop's still gonna want to give you the ticket? Could this be why, quote unquote, black people still ain't got reparations? Okay? Exhaustion of administrative remedies. Now, here's where it becomes interesting, because when you go back to People versus Graham, it was found, I have highlighted here, it was found that the trial court erred, right, in instructing the jury the burden of showing duress by the preponderance of the evidence was on Graham, the defendant. Rather, Graham had only to raise a reasonable doubt he had acted in the exercise of his free will. And basically, the long story of this case is what happened was, and I wasn't there, so I'm not a witness at all of any magnitude. Per the case notes, Graham said, he went into a store, he came out of a store, he went in the store, he looked around, he left, he came back into the store, and he started shopping, like, picking up items, and then he got to the counter, and he basically demanded that they the way he said it was, put all the money in my hand, right? That was the hold on, I gotta show you this. This is what it is right here. Hold on. So he told the clerk right here, put the money in my hand, right? The clerk did not understand what he meant until he displayed a knife. Then she emptied the bills from the till into his hand. So basically, he went in, per what was said on the case notes, what the court has gathered, so to speak. So he goes in, he looks around, he leaves. He comes back in, I don't know if he's got a basket or what, but he does some shopping. He puts some items, gathers some items. He goes up to the clerk and says, "Hey, put the money in my hand." She didn't know what she mean. Pulls out a knife. She felt like she was getting robbed. Put all the money in his hand. Um, he leaves, right? So of course it's deemed as a robbery. Now he comes back later on and says, "Hey, look, here's everything. I don't know if he gave him back all the money he took, the exact amount of money he took, or even maybe more money than what he took, but he gave back. He brought back like a bunch of groceries. It didn't say that they were the exact items that he took. It didn't say it was the exact same amount of money that he took or currency. But he came back and he gave bags of groceries and he gave money. And he explained that basically, hey, look, I didn't want to do that, but someone had put his life, had threatened the life of him. His family was like a heroin addict, he said, had threatened him, said that if he didn't go in and do that, that he was going to harm him, his wife, and the rest of his family. So he kind of felt like coerced to, or made or compelled to commit the robbery, so to speak. And he brought everything back and said that. So here's what happens with that, right? That's how he wound up getting found guilty, or was convicted of second-degree robbery initially and was sentenced to prison because despite the clerk saying that she believed him and everything, they found him guilty. Now, when they came back on the appeal side, the trial court, put this on the screen for you. This is why I'm saying the trial court erred, because in the procedures or the preliminaries, right, these words here of section 704, in a preliminary, procedural, or intermediate agency action, and here's where that comes up. The trial court erred in instructing the jury that the burden of showing duress by the preponderance of the evidence was on Graham. So basically what they went in and said was, hey, look, jury, this guy's got to make it very clear that, he's got to prove to you that he was acting under protest of duress during this robbery. When in reality, we know that that's the other side's job to do. They have to prove without a doubt that was not the case. All Graham would have to do, and it says here in the bottom line there that I've highlighted, all Graham had to do was only to raise reasonable doubt. You know what I mean? All right. So let's get back to this. Let me see here my notes. Let me make sure I covered everything for you. Because here's Darby. Yeah. So what happened was Darby said, I know we're jumping back to cases, don't get them confused. So this is the one with the APA. So Darby says that the federal courts do not have the authority to require a plaintiff to exhaust available administrative remedies before seeking judicial review under the APA, where neither the relevant statute nor agency rules specifically mandate such or mandate exhaustion as a prerequisite to judicial review. All right. And then it goes on to say that the language of subsection 10C of the APA is explicit that an appeal to superior agency authority is a prerequisite to judicial review only when expressly required by statute or when the agency requires an appeal by rule and provides that the administrative action is inoperative pending that review. Since neither the National Housing Act nor applicable HUD regulations mandated further administrative appeals, the ALJ's decision was a final agency action subject to review or subject to judicial review under Section 10C. The lower courts were not free to require further exhaustion of administrative remedies, although the exhaustion doctrine continues to apply as a matter of judicial discretion in cases not governed by the APA. So nothing in subsection down here, nothing in subsection 10C's legislative history supports a contrary reading. All right. So what they're saying basically is this, going back up here to this phrase where I told you in quotations. Where was that? Right here. It says that the ALJ's determination shall be final unless the secretary within 30 days of receipt of a request decides as a matter of discretion to review the administrative law judge's finding. You see, so this was very well played. Because the first court gave it to him like, yeah, y'all right, here you go, here's the bag. The second, they appealed it, the losers appealed it, and the Court of Appeals reversed it, holding that the district court had erred in denying the motions to dismiss it, and they were saying they wanted to dismiss it. The respondent initially said moved to dismiss the complaint on the ground that the petitioners, by foregoing the option to seek review by the secretary, had failed to exhaust their administrative remedies. But see, right here it says the LLJ's determination shall be final unless, see, this is why you can't talk to some people. They be arguing the wrong stuff. So it shall be final. So at the moment they made their decision, that was it. However, you have the option to remain climbing up the ladder or on that wheel, spinning around in the agency if you want to, right? And go to the secretary within 30 days of receipt of the request. The secretary has to decide as a matter. So what happens is that takes time. And that was the key element on, it may have been the luck of the draw for them realizing that the time it would take, right, could put them beyond the deadlines to appeal the case or decision. That could have just been a lucky observation, or they could have known this right here up front, that the LJ's determination shall be final unless they went the secretary route, meaning that they could go keep crying to the same system, you know what I mean, keep crying to the store manager. Oh, well, let me talk to your manager, right? Okay, well, now you're still at a manager within the store, right? You're not talking to corporate yet, right? All right. So they elected to go a different route, and this is why it was eventually given back to the favor of the original decision, because the administrative law judge's determination was deemed final per the regulations of HUD based on the verbiage, and they were not required to go to the secretary route. And that was the, I like the, we're going to get to the play-by-play here, if you want to call it such. But that's why he brought up a great point. One of the justices, if you want to call him, that where he said there's a difference between the wording of may and must. So basically it's one of those things where you're reading your contract and it says, hey, you may appeal, you may seek a remedy from a higher level within the agency, you know, by going to the secretary, and then if the secretary, you know, needs to respond within 30 days, blah, 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 you know what I'm saying? So I used the word may instead of must. So that meant that the fact that the administrative law judge's determination shall be final unless, all right, so let's get into the play-by-play. And this is, we're at about 45 minutes now into the video. Like, subscribe, all that good stuff. Share it with your people. Okay, we're going to make a transition here. If you want to support via PayPal, here's the link. You can support that way with some donations. If you want to support on CashApp, by all means, it's YNet7. So now let's get into the play-by-play. And this is approximately 59 minutes. I went over, or matter of fact, let me go over this for you, because we don't have this one today with this one. So the opinion, right? The opinion delivered. is the case presents the question whether the federal courts have the authority to require a plaintiff exhaust available administrative remedies before seeking judicial review under the Administrative Procedure Act. All right. So their response was their first response, which basically says a lot, is agency action made reviewable by statute and final agency action for which there is no other adequate remedy in a court are subject to judicial review. A preliminary procedural, we got this, right? A preliminary procedural or intermediate agency action or ruling not directly reviewable is subject to review on the review of the final agency action, except as expressly required by statute. Agency action otherwise final is final for the purposes of this section, whether or not there has been presented or determined an application for a declaratory order for any form of reconsideration, or unless the agency otherwise requires the rule and provides that action meanwhile is inoperative for the appeal of the superior agency. You've heard that a moment ago. So it says that we note here. So it says that we note that the statute as codified in the United States Code refers to any form of reconsiderations, with the last word. And it kind of jumped there, so I never figured out where it came back in with that hyphen, like before. But basically, here's what happened. It basically said that because they went and said the word shall be final, that was the final, and they were not required to follow the route of the secretary. One moment, please. I want to see if there's anything else I want to share with you. So here it is right here. So respondents move to dismiss the complaint on the ground that petitioners, by foregoing by foregoing the option to seek review by the secretary, have failed to exhaust administrative remedies. The district court denied respondents' motion to dismiss, reasoning that the administrative remedy was inadequate and that resort to that remedy would have been futile. In the subsequent opinion, the district court granted petitioners' motion for summary judgment, concluding that the imposition of debarment in this case encroached too heavily on the punitive side of the line, and for those reasons was an abuse. So that's why they were actually trying to get it. But where, hold on a second. Yeah. Mandate exhaustion. The issue. Hold on one second. See right here, they reversed it and remanded. So they reversed it. Oh, okay, here we go. So federal courts, and when I say they reversed it, you gotta remember the first court said, yeah, give them the bag. The second court, the appeal court said, no, wait, you gotta go back and do all this hoops. And then they reversed what the second court said to put it back to him. And here it is right here. So federal courts do not have authority to require the plaintiff to exhaust available administrative remedies before seeking judicial review under the APA, where neither the relevant statute nor agency rules specifically mandate exhaustion as a prerequisite to judicial review. So the language of 10C of the APA is explicit that an appeal to the superior agency authority is a prerequisite to judicial review only when expressly required by statute, or when the agency requires an appeal by the rules and provides the administrative action. Okay, so we went over this, but since neither, here's the actual part right here I was looking for. Since neither the National Housing Act nor applicable HUD regulations mandate further administrative appeals, the ALJ's decision was a final agency action subject to judicial review under 10C. And I know I just read that, but I wanted to reiterate the exact part of why. And it was made final agency decision because up here it says the ALJ's determination shall be final unless you go and want to request some more stuff. All right. So you got to make sure that we understand or comprehend exactly why. So now this section here, we're going to have the opportunity to review is to actually listen to the argument. So if you were good with just a review of that and understanding of 704 and the exhaustion of administrative remedies, gave you a couple examples of how it works, and even the part about being able to go back once the decision is made and review how that decision was made, but it has to be made final first. And we did that with the People versus Graham. So if you're good with that, by all means, I appreciate you. Share the video, like, comment, subscribe if you haven't already. And for those that enjoy the tennis match, we're going to go ahead and proceed. It's a total of 57 minutes and change left in the actual argument. We can listen to that now that we have an understanding of what we're actually listening to, for those that maybe weren't abreast on such topics prior to. And we can enjoy this contest here and see some of the structured argument as it's delivered from both sides. Okay, let's take a look at that. And this one also, like I said, doesn't have the opinion in audio. It just has the oral argument. So that's why I wanted to make sure I read that for you and gave you clarity there, because we won't have the official recorded replay of the opinion, which is basically their ruling. All right, let's get to it.
We'll hear argument first this morning, number 91-2045, R. Gordon Darby versus Henry Cisneros. Mr. Gordon.
Mr. Chief Justice, and may it please the Court. In enacting the Administrative Procedure Act, Congress provided a general authorization for judicial review of administrative actions. In Section 10C of the Act, it prescribed when and under what circumstances someone who is aggrieved by an agency action may seek recourse in federal court. Congress provided that a litigant need not exhaust available administrative remedies before proceeding to federal court unless such exhaustion is expressly required by statute or by agency rule. The question presented in this case is whether, notwithstanding that Congress has spoken, a federal court can impose additional exhaustion requirements and deprive a litigant of judicial review under the APA because he failed to pursue an administrative appeal that was not required by statute nor by the agency's own regulations. The answer to this question, we submit, is no. The facts of this case are straightforward. In 1989, HUD initiated administrative sanctions against petitioners, Mr. Darby and his affiliates. Mr. Darby contested those sanctions in full conformance with HUD's regulations. He litigated the matter before the agency for some 10 months through a process which included discovery, a 4-day evidentiary hearing, and the submission of post-hearing briefs. Ultimately, a HUD administrative law judge issued a lengthy written decision which upheld these sanctions.
Now, listen to that detail. He was already invested 10 months of contest with the agency just to get to that level. Imagine having to go now beyond that to the secretary. It's more time, more resources.
Pursuant to HUD's regulations, the ALJ's decision became the final agency action unless the secretary chose to review it. In this case, neither party sought such secretarial review. Mr. Darby then filed this suit in federal district court. He challenged the sanctions on the grounds that they violated the Administrative Procedure Act and the Due Process Clause. The government moved to dismiss for failure to exhaust administrative remedies. The district court denied this motion and proceeded to grant relief to Mr. Darby, holding that the sanctions were not rationally supported by the facts and that they had been imposed for forbidden punitive reasons. The government appealed to the Fourth Circuit, challenging only the district court's ruling on exhaustion. The government contended that HUD's regulation providing for secretarial review of an ALJ's decision required Mr. Darby to seek secretarial review as a prerequisite to filing suit in federal court. The Fourth Circuit rejected that contention. The Circuit Court recognized that no statute and no regulation required Mr. Darby to seek secretarial review. Nonetheless, it decided that as a, quote, rule of judicial administration, Mr. Darby was required to exhaust this administrative remedy. Since he had not done so, the court ruled that the district court should have dismissed his suit and left the administrative sanctions in effect.
Mr. Gordon, what if your client had in fact taken an appeal within the agency? Your position then is, I take it, that still in all, you would be able to come to court and prosecute an appeal both in court and before the agency?
Simultaneously, sir?
Yes.
Justice Scalia, I believe that that under the line of decisions, including particularly ICC, the Brotherhood of Locomotive Engineers, that at the point that the ALJ's decision became was issued, that Mr. Darby had an option, and that he could have either pursued an administrative appeal or proceeded to federal court.
Why is that? Because, I mean, the text of Section 704 reads, whether or not there has been filed.
And there was an interesting line of cases during the 1950s where the federal courts, the circuit courts, wrestled with whether if you pursued an administrative appeal, the time for your appeal to federal court would meanwhile expire. The Ninth Circuit, in a case called Consolidated Flowers, as I recall, held that you could lose your right to judicial review if you pursued the administrative appeal. The D.C. Circuit ruled to the contrary, and ultimately the Ninth Circuit reversed course. And I believe this court has recognized ever since the decision in the early 60s, CAB via Delta Airlines, that if you do pursue an administrative appeal, that the agency action is pending that appeal, not final, and therefore not appealable to federal court.
But why isn't that contrary to the language of 704? It says whether or not there has been filed. What I'm saying is maybe we've been playing with 704 up to now. Why don't we continue to do that?
Justice Scalia, I would submit that that is simply a practical and common sense application or construction of the statutory provision.
Well, because it would seem ridiculous to be prosecuting an appeal both before the agency and here, right?
Simultaneously,
Yeah,
yes,
but
sir.
couldn't the court consider it ridiculous for you to come complaining to the courts when you haven't completed complaining to the agency? Why couldn't I consider that ridiculous too, and say I certainly don't want to interpret 704 to provide for that?
Well, the court is not writing on a clean slate here. It seems to us that the fundamental principle is that it is for Congress to prescribe the jurisdiction of the federal courts. And this court has recognized repeatedly, and as recently as last term in McCarthy v. Madigan, that when Congress has prescribed that jurisdiction, that federal courts are not to decline such jurisdiction on exhaustion principles unless it's consistent with the expressed intent of Congress.
But I'm suggesting we've given that away. The language of 704 does not permit what you've just said we've done. The language of 704 says that it's final whether or not there has been lodged an appeal within the agency. But you tell me that if there has been lodged an appeal within the agency, we will not consider it final, despite the language of 704. Right?
That's correct, Your Honor.
The government is arguing, well, this is just another extension of the same principle.
I disagree, Your Honor.
See, let me the act in listening to this debate or this argument, the justice this one right here, Scalia, is basically, if you listen to what he's saying, he's dropping the gem right there. It's not that the lawyer or whatever you want to call him is wrong. It's just the justice is wanting him to narrow the focus down. Like, yo, if you just say it like this, boom, case closed. We can all go home. You know what I mean? Lunch is gonna be for another 4 hours. We can close this out right now if you just say it like this. And this is why, like, you know, when you talk to a Virgo and they be like, bap, 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 bap. And you're like, well, what does that mean? Can you tell me? And it's like we said, and then you spend 6 hours talking about something, and after the end of that 6 hours, they go, yeah, that's why I said those 7 words in the beginning. That's what I meant when I said those 7 words. Because there wasn't full comprehension of what the 7 words meant. We had to talk about it for 6 hours, around and around in the agency. You see what I mean? That's some of this application in your relationships, in, you know, communications at work and communications in business, the like. All right, so I'm gonna rewind it just a little bit, because this is why it's important, man. You know, we can't keep what we can't protect. And, you know, yeah, anybody can slap up somebody, anybody can put hands on somebody, anybody can gun someone down, but can you protect your family and your property in conversation, in paperwork, where you're losing everything and don't even realize it, don't even know why you mad, ready to slap someone else up? They ain't got nothing to do with it, because you're mad about something over here. So let's get back to this, because listen to what he's telling them. All right, just a little bit more.
The language of 704 says that it's final whether or not there has been lodged an appeal within the agency.
So right there, and if you go back to the HUD's thing, right, it said it was final, right here, under HUD's regulations, an ALJ's determination shall be final unless. So Justice like, yo, you say this, we can all go home.
But you tell me that if there has been lodged an appeal within the agency, we will not consider it final, despite the language of 704, right?
That's correct, Your Honor.
The government is arguing, well, this is just another extension of the same principle.
Because, again, it goes back to this, unless there's been lodged. And that's why he's saying, well, yeah, it wouldn't be final if we went to the secretary route. So really, none of this part of that conversation is called what's the word they use? Dictum, right? It's dictum because it really doesn't matter towards the initial or the final, what's going to be the final determination or decision. Let me give you the exact definition of dictum. Right? Like next time you have an argument with your spouse, say, look, this portion of the conversation is dictum, and I demand that we return our focus to the principal argument. Then you might be single like Pasha, because they be like, what? All right. Hold on, give me a second. All right, so dictum, and it's dictum, a statement in a judicial opinion not necessary for the decision of the case. I mean, it got more stuff after that too, but there you go. All right, let's get back to it.
I disagree, Your Honor. The Congress.
So, like, yeah, just I couldn't help it, but he's arguing the fact that if we go this route, it wouldn't have been final, which is all true, but it's dictum because all he had to say was because we didn't go that route, the decision that the ALJ made it final, and this is now what gave us the elements to be able to come to the court with it. Boom, case dismissed. End of discussion. But let's watch it. Let's watch how it play out.
If one examines the final sentence of Section 704, which is what is at issue here, has clearly dealt with the issue of exhaustion and not simply finality, as the government contends. The final sentence.
Well, exhaustion and finality aren't the same thing, are they?
No, just
think about this. Like I said, in your business, listen to this conversation now that we went over this. I just told you what dictum is. So think about this when you're talking about your significant others. Think about this in your business conversations. Think about this when you're talking to what you call your friends and family. And just listen to how much I showed you. Boom, it was done right there. It was done. Case closed. This is why people like me get, may appear frustrated, because it's like, man, I said it. That's the first thing I said. Why are we still talking about this? But we realize, the wise ones realize that, hey, look, you can plant the seed now. Maybe they need 6 months before it makes sense to them. Meanwhile, you're not going to stress me out. But what emotions will have, people that communicate emotionally instead of with words, right? They're looking for the emotional response. So you never gave them an emotional response. You gave them remedy. They don't realize that they have the remedy because they didn't never get the emotional response they wanted. So now, are you going to sit there and continue to badger and stress yourself out? No. You're going to go ahead and live your life. Meanwhile, they talking all kinds of stuff about you because they don't understand or comprehend or know what you place before them. So just listen. Now he's going to win the case. I mean, we already went over that in the beginning, so it's not like there's a spoiler. He's going to win the case. But listen to all the time wasted, because the way this works is you get a certain amount of time, and he does reserve some of his time at the end to refute some of the things that the other party brought up. But we could have saved all that time now. Like, look, bro, it was final when the ALJ gave it to us. This is why they don't like you talking to. This is why certain bosses you got, certain supervisors you got, don't like talking to you, because you're not emotional. You're coming at them from a different level. So we went into work and you told them, hey, look, the ALJ gave it and said it. That made it final. I'm taking it to the next level. And they're like, no, you got to go over here and talk to Bob. And you're like, fuck Bob. That was final. I'm going here with it. You see what I'm saying? Because you comprehend. They're not used to people comprehending. They're used to people being emotional. That's why I fight so hard to get you to understand the difference. Okay, let's keep going.
Justice O'Connor, they are not. They are closely related.
I don't see how 704 deals with exhaustion at all.
If I may, Your Honor, the first sentence.
Now we go all the way. See what I'm saying?
You
open the door.
Requirement.
Now you in
second
that
section,
just like your conversation with your
provides
with
that
your
intermediate
girlfriend
rulings or procedural or preliminary rulings are not directly appealable, but may be heard when the final agency action is appealed. The third sentence, which is what's at issue here, presupposes final agency action and goes on to address whether there are additional procedural requirements that a litigant must follow. We would submit that that it is clear that this provision deals with exhaustion and not simply with finality.
It certainly isn't clear to me because all it talks about is finality, and I would have thought that 704 simply doesn't address exhaustion.
I believe that there are, beyond the construction of the provision itself, the sentence, Justice O'Connor, we submit would be superfluous and inexplicable if it deals simply with finality. The finality requirement is already clearly set out in the first sentence. Moreover, in the legislative history, and in particular in a explanation of the APA that the Justice Department did, and which was provided to Congress at the time it was considering the APA, the Justice Department said explicitly that the last sentence of Section 10C dealt with the issue of exhaustion. And that legislative history is quoted in our brief.
Well, Mr. Gordon, the opening clause of the last sentence, which you're talking about, says, except as otherwise required by statute, agency action otherwise final is final for the purposes of this section. That is surely dealing with finality. I mean, it says so in so many words, and it says nothing about exhaustion.
Mr. Chief Justice, when it speaks, it uses the word finality twice. Except as otherwise provided by statute, agency action that is otherwise final is final for purposes of this section. And that phrase, final for purposes of this section, that is the same thing as saying it is reviewable, because in the first sentence, the Congress said it's reviewable.
I don't agree with you. Why should we read it that way? It certainly doesn't say so in so many words.
Well, among other things, 5 years ago in Bowen v. Massachusetts, the court stated that the primary thrust of Section 704 was to codify the exhaustion requirement.
That was just an offhand remark in that case.
I agree that it was dictum, sir, but
right now what they're doing is they're from what I learned about the rules of engagement of arguing is they're applying the technique of looking to destroy or find a hole in how he came to that conclusion. See, they know he right? And this may be the case with some of the people that you're arguing with too. They know you're right, or someone may not, and they just may be answering the question. And that's where I would have been like, no, we're going to focus on this right here because this is all that matters. The rest is dictum. All right, now last year I wouldn't have used the word dictum, but this year I'm using 2022 onward. We're talking dictum. All right, so now the angle that they're using is let's crack a hole in here where we can make an argument that shows a lack of confidence in how one arrived at that decision. And this is actually why in your personal relationships, whether that's your job, your boyfriend or girlfriend, this is that gaslighting this is the success of gaslighting. Make you feel like there's something wrong with you. And that's why I hear him saying, well, we don't agree with that. What about this? And what about that? They know he already won the case in the first sentence. All right? This is what some people do when they talk to you, too. So not only are you gaining the benefit of watching and learning about the law and the applications and actually getting some insight on the play-by-play inside the courtroom, but you're actually making yourself a stronger person in your business, in your home, and in your friends and family relationships. All right? Let's continue. Pasha Paroh.
I believe it was the correct interpretation. It's consistent with the legislative history. It is also consistent with the interpretation that scholars have placed on this uniformly, including most particularly Professor Davis in his text, and also other commentators in various law reviews that we have cited in our briefs to the court. The view that has been expressed uniformly is that that sentence deals with exhaustion of administrative remedies. It is true, and Professor Davis and this court in Bowen have noted that the courts have tended to ignore that sentence in many decisions. But that doesn't change the fact that that is what's being addressed there.
Well, let's just assume that 704 deals with finality, but it does deal with finality, and it says that it seems to say that there was final agency action here. Now, is there a time limit on when you can resort to the courts to review a final agency action?
Justice White, I'm not aware of any specific time limit under the APA for filing suit once you do have final agency action.
And so it might be final for purpose of going to court unless, well, it'd still be final for the purpose of going to court, but you may be barred from going to court by the exhaustion principle. That's the argument on the other side, I guess.
Yes, Your Honor. And the difficulty that we have with the government's position is that it turns Section 10C into a trap for the unwary litigant. Mm-hmm. The exhaustion requirements must be consistent with the will of Congress. Congress, in the last sentence, has said in Section 704, you must have final agency action in order to seek judicial review. It says that if you've got, whether or not you have that action, and it deals specifically with an administrative appeal, and it says that you don't need to pursue that appeal in order to have finality, which it defines as the prerequisite for judicial review, unless you are expressly required to do so by statute or by agency rule. It insists, therefore, on clear procedural ground rules that are spelled out in advance. And what the government has done here is come in and sought to obtain through litigation what it never got through rulemaking. There is no statute, that's agreed. There is no regulation, it's agreed, that requires a litigant to pursue this appeal to the Secretary. And yet, the Fourth Circuit said, propounding a rule that was completely inconsistent with existing law, that there is this hidden requirement that it has been a rule of judicial administration that you must exhaust all available administrative remedies.
Mr. Gordon, let me ask you this. Suppose we think that 704 deals with finality, not exhaustion, and that courts do retain the equitable discretion to decide to require exhaustion in a given case. Would your argument then go to whether the court properly exercised that discretion?
Yes, Your Honor.
And if so, is that question here, or would the court have to send it back for that inquiry?
Your Honor, the question presented in the cert petition dealt with whether or not Congress has disposed of the issue in Section 10C.
Mm-hmm. And suppose we disagree with you on that.
I don't believe that it would be necessary to return the case to the Fourth Circuit, although we'd certainly be prepared if that was the court's view of the appropriate procedural device to do it. Even if Section 704 dealt only with finality, which we do not agree with, it is at a minimum an expression of congressional intent and purpose in the area. And to impose an exhaustion requirement that is 180 degrees in conflict with what Congress has indicated there, we believe would be completely inconsistent and at odds with this Court's jurisprudence saying that courts must defer to, be careful to search for congressional intent in the area and to follow it, and not to impose an exhaustion requirement unless it is clearly consistent with what Congress wanted.
Suppose, I suppose you get relief from an agency action sometimes by appealing to the Court of Appeals, don't you?
Under some statutes.
Under some statutes?
Yes, Justice White.
Well, suppose the agency in that situation had exactly this kind of a non-required appeal to the Secretary. And yet the agency order would be final just like it is here. Is there a time limit usually to go to the Court of Appeals?
Justice White, I'm not aware of any provision under the APA that would permit an appeal directly to the Court of Appeals. I believe that any appeals directly to the Court of Appeals would be under other statutory schemes and therefore outside the context of the APA. And I do not know whether there are normally time limits that are imposed in those statutes.
But how do you know in those cases when an agency action is final?
If those are separate statutory schemes, they wouldn't be controlled by the APA. We are not contending that Section 704 governs exhaustion of administrative remedies in review contexts that are outside the APA.
I take it that you have to, under your view, even wait for 30 days before you can go to court to determine whether or not the Secretary is going to appeal?
In the background, so how the hell do you know? Look, you gotta give it to this. If you want to call it lawyer, or whatever. Because see, one of the things you gotta do, people, is you gotta have your shit bulletproof. That's why when you stand on authority, when you make the authority your truth, because we know that the word truth puts people in position to say, oh, well, that's your truth. It's not my truth. It's like, shut the fuck up, man, with that shit. Look, the truth is what? When people get real with themselves, the truth isn't mine or yours. It's what's the authority. Everything else is just a belief. Okay? So when you're dealing with someone that only speaks from authority, their truth is the authority. So that, but anyway, what I'm getting at is, you gotta have your shit bulletproof. And they coming at him trying to poke all kinds of holes in there, and he handling this shit right. Okay? So let's get back to it.
Actually, Justice Kennedy, I believe it would be 15 days. Under the HUD's regulations, the parties have 15 days to...
He got the justices sitting on there like, how the hell do you know that
petition for secretarial review. In this case, neither side petitioned within the 15-day period, and therefore, at that point, we believe that it became final.
If there had been a petition, in your view, what would then be the posture of the case so far as judicial review if the department had petitioned the Secretary for the Secretary to review?
That's a very interesting question, if I may. If we had the normal situation where a situation where the sanctions were not in effect until there was a final decision, and the sanctions were going to be stayed pending secretarial review, clearly we would not have a final agency decision that could be appealed to federal court pending the secretarial review. The interesting twist that you have in the administrative sanction context, the suspension debarment context here, is that the sanctions are in effect during the period that you're litigating before the agency. And therefore, I think that is a crucial distinction between this circumstance, for example, and the one presented in FTC v. Standard Oil, where this court has held that simply filing an administrative complaint is not in and of itself appealable final agency action.
Would the sanctions have remained in effect, I take it, if the agency had petitioned to the Secretary for review?
The LDP would have. You get into some technicalities. The debarment would not have been effective until the secretarial review was completed. But there were simultaneous sanctions here, and there was a limited denial of participation that had been in effect from day one and remained in effect throughout the litigation before the agency.
And I take it the agency could appeal to the Secretary to impose a more severe sentence, or a more severe sanction?
Yes, sir. In fact, the agency had sought an indefinite term of debarment. The ALJ had granted them only 18 months. So they had not gotten the period that they'd asked for, and therefore they would have had a basis for asking for a heightened sanction.
But I take it even under your view, the regulated party could not avoid the possibility of the department appealing to the Secretary by rushing into court because you have to wait for that 15-day period?
That's correct, Your Honor. And we have noted also that the government has suggested that to follow our position in construction of 10C would invite sort of piecemeal, haphazard judicial review. And we don't believe that that's the case at all. And we have cited a variety of other doctrines that we believe give the courts full power to keep appropriate control over litigants who would rush into court prematurely. And those include the doctrine of ripeness, the doctrine of finality, the requirement that in order to have, when you're seeking review under the APA, that your record is limited to the record you've created before the administrative agency itself.
What about the government's argument, as I understand, Mr. Gordon, that you may, if you adopt your position, a litigant can obtain judicial review before getting a fully fleshed out decision from the agency, that you might get a more comprehensive decision from the agency if you exhausted your remedies?
Mr. Chief Justice, I suppose to some extent it's a truism that you may get a more fleshed out decision if you proceed further within the agency. That's always at least a possibility. Under HUD's regulations, secretarial review is limited to the record that's been created before the ALJ. And so in this case, all you could have gotten would have been some further elaboration of the rationale for proceeding from those facts that had already been found by the ALJ.
But, Mr. Gordon, wouldn't the logic of your position even apply to the case in which there has been no record made at all? Would it not apply to a structure, for example, in which debarment can be announced without a hearing by an agency officer, whereupon the contractor has the right, if it wishes, to request an ALJ review of that debarment? All right, now, with an appeal later to the Secretary, the rest of it just like the current system. In that situation, wouldn't you maintain that you don't have to go through the hearing at all? You could get debarred, simply not go to the ALJ, and come right into court. Wouldn't that be your position?
No, Your Honor.
Why not?
Justice Scalia, it would not. First of all, in a decision announced 2 weeks ago that you wrote in Ryder v. Cooper, you noted that exhaustion, that to completely bypass an administrative remedy would violate the exhaustion requirement. 10C of the APA deals with pursuit of administrative appeals. We do not contend that 10C deals with it talks about an appeal to superior agency authority. We do not contend that it covers a situation in which there is a complete failure to contest before the agency, a complete bypass of the agency. And the D.C. Circuit dealt with that sort of a case, we believe, in the Peter Kiewit-Sons case, which is cited in the government's brief. But beyond that distinction within the exhaustion doctrine itself, between a basic failure to go into the agency at all versus pursuing an administrative appeal, which is what we're talking about here, if you simply left the debarment in effect in your scenario, you would have no administrative record other than what the agency has created to go forward on in appeal. Under the L.A. truck lines case, what arguments have you advanced before the agency? The court's going to uphold you to those that you advanced before the agency. And there are, the ripeness doctrine might be invoked there as well by a court, and we do not contend, and we've made this very clear, that we think that Section 10C controls the exhaustion doctrine. It does not. It simply deals with the issue of procedural defaults. That's, in our view, what exhaustion is all about, procedural defaults, as opposed to whether or not a case is ripe for review by the court, and the court is in the appropriate position to rule. I would note that Senator McCarran, who was the principal sponsor of the APA in the Senate, described it as a charter of private liberty and a solemn undertaking of official fairness at the time it was enacted. He said that it was intended to provide, quote, a guide to him who seeks fair play and equal rights under law. In this case, it is undisputed that the HUD sanctions were arbitrary and unlawful. Mr. Darby followed the guide that the APA set out. He did everything that HUD required him by regulation to do, and he did everything that the APA instructed him to do. Yet, when he sought redress in federal court, the Fourth Circuit said that he had not done enough, and that he had forfeited any opportunity to seek to right the wrong that HUD did to him. The Fourth Circuit's decision we submit nullifies the promise of fair play that Congress made in the APA. And we would ask this Court to affirm that promise that Congress made 50 years ago. Thank you very much. I would like to reserve my remaining time, if I may, Mr. Chief Justice.
Very well, Mr. Gordon. Mr. Feldman, we'll hear from you.
Mr. Chief Justice, and may it please the Court. In our view, petitioner's argument makes a wrong turn because it relies on the wrong provision of the APA. Section 10C, by its terms and by its intent, deals with the doctrine of finality. Section 10A of the APA, 5 U.S.C. 702, which is the basic provision providing a private right of action for those aggrieved by agency action, that provision provides the sufficient conditions for obtaining judicial review. In 1976, Congress determined...
Is it your view that 10A creates the exhaustion doctrine, codifies the exhaustion doctrine?
It's our view that Section 10A is the basic provision that gives you a right of action for judicial review.
And that's what requires exhaustion.
Well, and then...
And what language in 10A requires...
Right,
what is 10A? Could you give me a code number for 10A?
702. It's on 1A in the appendix to our brief.
1A on your brief.
Yes.
You'll help me if you tell me what language in that section talks about the exhaustion doctrine.
I think if you talk about prior to 1976, I think the first sentence... Well, I think the statute didn't specifically in terms address the exhaustion doctrine prior to 1976.
Unless it did it in 10C.
Right, it didn't address it by its terms. Yeah. But I think the understanding was, not only with respect to exhaustion, but as counsel conceded, with respect to ripeness and primary jurisdiction, other doctrines which have traditionally been equitable doctrines that govern the timing and availability of judicial review, I think everyone believed that those doctrines were available and limited judicial review in the period between 19...
My question is there any language in 10A that talks about exhaustion?
Prior to 1976...
Either before or after?
Right. After 1976, the word exhaustion isn't mentioned, but I do think that when they added the proviso saying nothing herein affects other limitations on judicial review or the power of a court to dismiss or deny relief on any other appropriate legal or equitable ground, when Congress added that proviso, the doctrine of exhaustion of administrative remedies, like the other doctrines I mentioned, are plainly encompassed within the terms limitation on judicial review or appropriate equitable grounds.
And where before 76, where did you find the exhaustion doctrine in the statute? Were we just plain wrong in the Bowen opinion saying we thought it had been codified in 10C?
Well, I think the Bowen opinion was addressed to a different question.
Was that statement just plain wrong?
No, I think insofar as it's I think it was not a full
statement. We said in that sentence that we thought 10C codified the exhaustion doctrine. You're telling me that's wrong. The exhaustion doctrine was in some other part of the statute or somewhere up in the sky.
I think it was in 702 at that time.
But no language mentioned it, did it?
It was not an issue that was important in Bowen, but I would say there was a footnote in Bowen which I think states our position precisely. On page 902 in footnote 35, the Court said, it is certainly arguable that by enacting Section 704, that's 10C, Congress merely meant to ensure that judicial review would be limited to final agency actions and to those non-final agency actions.
Which is entirely consistent with the notion that the exhaustion doctrine determined when an action was final.
Well,
that would be final until there was exhaustion. Well, that's entirely consistent with the text on the next page.
I think that would be an additional premise, but our position is that that finality and exhaustion are distinct doctrines. The Court has referred to them as distinct doctrines on a number of occasions. The Court did it last.
The exhaustion doctrine is entirely non-statutory.
Yes, except that I think 702 shows that Congress in 1976, when it was amending the statute, plainly thought that exhaustion, as well as these other doctrines, still applied. There's nothing unusual.
Of course, that language would still have exactly the same meaning if the exhaustion doctrine were part of 10C. The amendment of 76 didn't take away any defenses that were already in the books, including the requirement of finality.
Well, the amendment, the legislative, the reports and so on, which explicated that phrase, specifically mentioned exhaustion as well as a number of other doctrines.
But it did mention exhaustion as something separate from what was in 10C?
No, but it talked about traditional equitable limitations and traditional defense. Under petitioner's view in this case, it's hard for me to see what remains of the exhaustion doctrine after 10C. There's now a codified rule that no longer governs.
What remains that if the agency wants them to, in every case, if they want the applicant to make the petition before the Secretary, they ought to have a rule that says so.
Right.
And they can require it. In which event the agency action isn't final.
Right.
If the agency so provides by rule.
That's right, and that, I think, is a codification of the traditional rule of finality. Finality has to do with when an agency is satisfied that its decision can take effect at a certain point. It doesn't have to do with whether there's an additional administrative remedy that's available to a litigant to cure a defect in an agency action. That's traditionally the distinction between the two doctrines, and there's no reason in the language of Section 704 to think that it was dealing with the latter situation.
Well, Mr. Fellman, if you are correct that exhaustion is something that the court in its discretion can impose, do you think that the court can properly impose it in circumstances where it does become a trap for the unwary?
I think that first of all, I would say I don't think that question is presented by this case, but I think it is an equitable doctrine, and the court has repeatedly said you look at all the circumstances. There may be cases in which there was a trap for the unwary, where
like in this case. I mean, it certainly came as a surprise to the litigant here, apparently, that exhaustion would be required. I think it would come as a surprise to me, reading the statutory scheme.
I think, actually, I would, with respect, differ on that. I think that a seasoned litigant before an administrative agency shouldn't be surprised to know that he has to follow an internal appeals process that can, especially up through an agency's ranks, before he can go to court. I think that has been an accepted rule that people would be surprised to find they didn't have to follow.
Well, would it have been an abuse of discretion for the district court to entertain this action?
I think that if a district court let me add one other fact, and then I can answer that, which is petitioner has never claimed that I'm aware of in this litigation that he wasn't aware of the internal appeals process. But if you take a case, for instance, where a litigant honestly wasn't aware of the existence of administrative appeal process, I think that would be a factor to be taken into consideration in the equitable weighing that happens when you apply the doctrine.
The more you make it equitable and discretionary, Mr. Feldman, it strikes me the more likely it may be a trap for the unwary. I mean, if you don't know until you get to court how a judge is going to decide as to whether you should have exhausted that last remedy, then the doctrine really does have some potential for mischief.
I would say that in general the doctrine is not complex. It says if there's an adequate remedy that's not futile, where the decision maker is not biased, if it meets some of those basic prerequisites, you are required to undergo that before you go into court.
Well, then you're not talking about something that is discretionary in the sense the district court weighs all the facts in each case. You're talking about a general rule that might be subject to some exception?
Yes, but I would say, for instance, in the question of what is an adequate remedy, the courts have discussed a number of different types of factors. There might be a case where the failure to publicize a process or impossibility for a litigant to find out it was even in existence.
But Mr. Feldman, in this very case, your position, as I understand it, is that the sentence that says any party may request such review in writing within 15 days really means every party must request review if that party wants judicial review.
That's right. That's right.
And I think that's misleading language.
No, I don't think so. I think that is the consequence of having an equitable doctrine such as exhaustion that has been applied for 100 years to administrative proceedings.
Yeah, but it hasn't been applied this way since the Administrative Procedure Act was enacted. Most of that 100 years was before it was codified in 704.
Well, we would disagree that it is in 704.
Mr. Feldman, what is the purpose of 704 if it isn't that? I mean, I agree that finality and exhaustion are different concepts, but so are animal and dog different concepts. But one is a subspecies of the other. Why isn't exhaustion one sort of lack of finality? It's not final because you haven't exhausted your administrative remedies. Why isn't that a perfectly way to explain why exhaustion is different from finality, but nonetheless makes sense of Section 704?
Well, I think Section 704 serves a different purpose, or this last sentence of Section 704. What that does is it permits an agency to create a rule saying you have to take this internal agency appeal, and regardless, and then at that point,
No, but
that is a
That's not what the APA was. The APA was sponsored by the American Bar Association to stop these newfangled agencies from jerking people around. And the purpose of 704 was explicitly to stop agencies from making you go through one hoop after another hoop before you could get to court. Isn't that the purpose of it?
Well,
I always thought it was.
Actually, I don't think so. I think 704, 704, my reading of it, it provides necessary conditions for taking advantage of the procedure for judicial review that was created in 702. And those are conditions, and among things, I think it would be common ground in this case, that among the effects that 704 has is if the agency were to adopt a rule saying you have to take an internal agency appeal before you can get into court, if an agency were to adopt that rule, the litigant would have to do that, regardless of any application of the exhaustion.
But you're saying they have adopted that rule.
No, I'm not. No.
Yes, you say that's the fair reading of that last sentence.
No,
you must do that in order to get into court.
If they do it by rule, what 704 does, and I think this is
I'm saying that the Secretary's present regulation is, as you interpret it, exactly that kind of rule.
No, well, if I said that, it was perhaps a little misleading. What I meant was...
Well, I said, isn't your interpretation of this sentence that he must apply within the 15 days if he wants to go into court?
The legal consequence of that rule is that...
Is exactly what I said.
I guess perhaps not exactly. The difference is the legal consequence of that rule, the rule that's currently in the regs is if he wants to get into court, he should exhaust his administrative processes unless the administrative remedy is inadequate or futile or comes within one of the other exceptions to it. If the agency had adopted a rule that said in terms you must take the internal agency appeal before you get into court, then the existence of those exceptions would be irrelevant. The agency would therefore have the power to say you have to do it, and assuming its rule was valid, you would have to do it. And that's what the power...
So what you say means is you must file within 15 days unless you want to assume the burden of proving that remedy is an inadequate remedy.
That's right.
That's what it means.
That's right. And I think that was a reasonable thing for Congress to do, to give agencies the power to do that, but without upsetting the exhaustion doctrine, which gives agencies a chance under the common law that had developed prior to the APA and which was preserved in Section 702, to hear litigants' complaints, and make rulings as to, and make sure that their decisions are in accordance with agency policy.
Mr. Feldman, do you know if this may language is common among the agencies in terms of internal review?
It's quite common. I can't give you a percentage.
Why would they say? I wonder why they use the word may. It seems kind of silly to me.
Well,
why don't they either put up or shut up?
Well, one reason that they use the word may is if you think about wording a regulation that accomplishes this purpose, they're not requiring litigants to do something. They're saying you may take an appeal if you're dissatisfied with what you got from the ALJ after you look at all things considered. You may take an appeal to the superior agency, to the secretary.
But the agency, in using may, bars them from going to court right away.
That's right. But that is a standard application of the exhaustion doctrine, which always has had the effect of barring people from going to court if there's an alternative administrative remedy. This case, in fact, is a very...
704 seems to say that if you want to postpone finality, if the agency wants to postpone finality or hold up going to court, the agency should do it by rule. Right. Do it by rule and say that the action, with a rule that says that the action is meanwhile inoperative, so it isn't final.
As I said, an agency can adopt a rule, and that has a rather different effect than the rule that they did adopt. The effect of a rule like that under 702, under the authority of 702, is to make it an absolute requirement that you go to superior agency authority, regardless of whatever the equitable factors might be or the exceptions to the doctrine of exhaustion. The effect of just simply creating a remedy for a litigant, as in any other case where the agency creates a remedy for a litigant, or as here, where this, in fact, is a case similar to what Justice Scalia mentioned earlier, where the procedure starts by the agency sending out a notice of proposed debarment. If the litigant doesn't do anything, he is debarred, I think, within 30 days. I'm not sure of the exact period. Now, it permits the agency, the litigant may ask for a conference at that point. I think the rule uses the word may in that context as well. The litigant may go to the ALJ, he may present evidence, or he may not. That doesn't mean that if he sits on his haunches, he can go into court prematurely.
But of course, as Mr. Gordon said, the ALJ before whom he would have the hearing cannot really be described as a superior agency authority in that context. So I don't know that 704 would comfortably be applied to that situation.
There are whether he would be a superior agency authority or not is maybe isn't worth getting into on the facts of this particular case. But in any event, there could easily be cases where that would be the case, where you get a proposed. I know the Department of Energy has proposed remedial orders. It's a very common way for administrative proceedings to run. In this case, it happens that the notice of proposed debarment was sent, I think, by an assistant secretary.
What is the great disaster about our just saying? I frankly don't see what 704 was directed at, unless it was the problem of the agency setting up one obstacle after another before you can finally get to court. And what 704 says is you can do it, but if you want to do it, your action cannot be effective. You have to announce in advance, and the real bite is your action cannot be effective. You cannot debar. You have to just propose to debar, and then you can make me jump through as many hoops as you like, but nothing happens meanwhile.
And that indeed was what happened in this case.
Well, no. The final debarment had not occurred.
But what had happened was
there was a disqualification from.
There was a limited denial of participation, which was issued by a local HUD office, which had a very limited effect. It applied to just the local office and just the program that Mr. Darby was involved in. That took effect before even the notice of proposed debarment went out. And that was simply a means for the agency to protect itself while anything else was being litigated. To say, if we suspect someone of having defrauded us or swindled us or however you characterize what they suspected happened, if we suspect somebody of doing that, we need a way to protect ourselves while we can't just let this person go on and contract in the same program with us until we can find out the facts and figure out what happened. The rationale for limited denial of participation is different, very different from that of a debarment. And we could discuss whether that's a good idea or whether an agency ought to be able to permit it to do that. But if that limited denial of participation is sufficient to permit a litigant to go directly into court, then he doesn't have to wait for anything. That happened actually even before the debarment proceedings had started here. I mean, in fact, I think that's a reasonable way. That serves the purpose of protecting an agency's particular program while a debarment is being considered.
You don't say that that this permissive review wasn't available to this person, do you?
It was available.
Yeah.
It was available at the same.
And I suppose the secretary had turned him down. He could go to court.
That's right.
Mr. Feldman, let me ask you a question Justice Scalia can't ask you. That is, isn't the legislative history against you?
I don't think it is. I think there's about 3 or 4 different strands of the legislative history. One is the consistent statements that this was intended to codify existing law. I think that cuts strongly in favor of our position. Second, there was Attorney General Clark's statement.
Oh, you're talking about 1945?
Yes, I'm talking now the earlier legislative. That the exhaustion doctrine, as it applies to finality, I think is the word that he used, then is codified in this section. I think what he indicated by that plainly was that he was talking about finality and not exhaustion. He wasn't saying the exhaustion doctrine apart from concerns of finality. He was talking about finality.
Except that some of the language of the section itself is just as consistent with exhaustion as it is with finality in a very narrow sense. I mean, you yourself said 10A can be dealing with exhaustion, though he doesn't mention it, and I suppose the same thing is true of 10C. And when you've got text that refers to requests for reconsideration and appeals to superiors, I mean, that smacks just as much of exhaustion as it does of finality in the narrow sense, doesn't it? So that would be consistent with that legislative history that you try to explain away.
I think that all I can say is that when Attorney General Clark, I think, used the words "as to finality," he was talking about finality and not exhaustion. And this court has, in a number of cases, distinguished between the two.
But the text still, I mean, the text in references to reconsideration and superior authority is dealing, despite its finality language, is dealing with exhaustion concepts, is it not?
I think that those things could be relevant to either. There's certainly overlap between ripeness as well. A petitioner hasn't alleged hasn't said that Section 10C eliminates the ripeness doctrine, but I actually don't see why it wouldn't have that effect, at least in many cases, under his reading of the statute. But the other comments from the 1945 or 1946, they're perfectly consistent with our reading. What they say is it permits the agency by rule to require an appeal to superior agency authority. At that point, that is codified. It is a prerequisite, a necessary condition for obtaining judicial review under the statute. And an agency can do that regardless
it provides for a necessary condition.
Right.
It does not impose it itself.
That's right, provides for it. And regardless of whether you would meet any of the traditional exceptions to the exhaustion doctrine, regardless of whether somebody would view it as inadequate or futile or whatever, an agency can require you to go through these processes, assuming its regulations are valid. In 1970,
in this discussion of legislative history, are you talking about the Attorney General's manual?
There was the Attorney General's manual actually came afterwards, but there was one. There was, I believe,
that's why
one
I wonder
comment.
how that's legislative history.
Right. I was really talking about the Attorney General's comments to that were submitted to Congress prior to the enactment of the statute, and there was one comment, I think, on the floor in a committee report that was similar to that. The Attorney General's manual just said more or less the same thing. But all of those comments, except for Attorney General Clark's first statement, are perfectly consistent with our view, which is it permits an agency to require someone to appeal to superior authority without any of the limitations of the exhaustion doctrine. That's what it does, and those are perfectly consistent. In 1976, though, I'd add, I think that if you look at the legislative history, first of all, 702 has something which 704 doesn't have. That is, 704 has no general term which could encompass the specific doctrine of exhaustion. 702 does. It talks about traditional limitations on judicial review and appropriate equitable grounds on which a court may deny relief or dismiss a case. It seems clear to me that those, even just on the language apart from the legislative history, plainly apply to the exhaustion doctrine. It certainly is a traditional limitation on judicial review.
Well, they also plainly apply to the finality requirement. And if the finality requirement includes the exhaustion doctrine, they apply to both in the same time.
Right. Well, it says nothing herein, and I would take the herein to be with respect to the way this statute, to the work that these provisions of the APA are doing. And therefore, to refer also to if insofar as
well, nothing herein was meant to be this additional waiver of sovereign immunity, isn't to waive any other defense.
It says affects other limitations. Actually, that was the term I was trying to appeal to.
What does herein
other
mean?
Limitations.
I thought herein meant Section 702.
Well, it probably refers to Section 702. I don't think it really makes a difference.
The waiver of sovereign immunity in particular. They're saying in waiving sovereign immunity, we're not waiving all these other things.
And
but we're not talking about 702. We're talking about 704. The issue is what 704 provides.
I think what Congress intended by the herein is in doing what 702 does, which is create a statutory cause of action for judicial review, that in creating that, Congress did not intend originally, and certainly in 1976 made clear that it didn't intend, to upset these traditional doctrines such as exhaustion and primary jurisdiction.
Well, Mr. Fellman, on that point, what is traditional, are there cases out there that were decided before the adoption of the APA that clearly said exhaustion is required in the situation of a discretionary agency appeal? I hadn't spotted any, and I wondered if you had.
I haven't spotted any, actually. I haven't spotted cases that...
Seems to me.
Well, it depends. Wouldn't you agree that Myers against Bethlehem Steel is the classic case on exhaustion?
Yes.
And isn't that a finality case? The holding of the court is no one is entitled to judicial relief for a supposed or threatened injury until the prescribed administrative remedy has been exhausted. That's what the case held.
Right, and
that's what was codified in this. You don't think so?
I don't believe it. I think that's actually a codification of the exhaustion doctrine. If you look at cases such as Aircraft and Diesel against Hirsch, that was a case where someone went to the renegotiation board, had a ruling against them, and instead of pursuing what is very comparable to what happened here, which is an appeal to the tax court in that case, but to a superior authority, he went directly into court to complain about the administrative action. This court held that was barred by the exhaustion doctrine. In fact, it was barred by the exhaustion doctrine regardless of whether he could ever have gotten an appeal from the tax court judgment in that.
It's still not clear to me what your position is as to whether or not it would have been error for this court to proceed if it had chosen to do so.
It would have been error for the district court
yes.
to proceed here? My position is our position is the district court well, I think there's nothing on the facts of this case that suggests that the Fourth Circuit decided it wrong. The kinds of things that petitioner raised...
Suppose the district court had proceeded with this case. Is that an abuse of discretion or some other error?
I would say...
We're talking about an equitable doctrine, and I want to know if the district court or a district court situated in a case like this would have the discretion to proceed if it chose to do so.
Since discretion necessarily allows a range of judgments, it's hard for me to say that there would be no circumstances, especially if you filled in some additional facts, that a district court could have proceeded in this case. But I don't think that the facts that were before the Fourth Circuit or the arguments that were made by petitioner were sufficient to excuse him from the exhaustion doctrine. The arguments that were made by petitioner about whether the doctrine applies were that the administrative remedy was inadequate because the secretary could extend the time period, even in the absence of any showing that the secretary ever had extended the time period, and even where the time periods are relatively brief, 30 days or so. I think he could have had a complete judgment in 75 days. The Fourth Circuit rightfully said, well, that's not a basis for excusing exhaustion, where you have no basis to say the secretary wouldn't have just followed the time deadlines and the rules. I think the petitioner also claimed that it would be futile to pursue the administrative remedy, but there's no reason to think either that would have been a factor here. That's simply his speculation that he would have been unsuccessful. I think that, in fact, this case is a classic case where exhaustion should be required. The Court has said exhaustion is particularly potent where administrative discretion is at issue and expertise. Well, the decision whether to debar is expressly made a discretionary decision, and it involves weighing the seriousness of the acts against the mitigating circumstances and so on. Those are decisions that the Secretary should have had a chance to make if petitioner didn't like them before the ALJ's decision was reviewed by a court. In addition, of course, there's a lot of expertise involved here in interpreting HUD's regulations and in interpreting the debarment procedure itself and the standards for debarment, as well as the substantive standards governing the program the petitioner participated in.
Your position is that this May-type internal review suspends finality. I mean, it destroys finality for purposes of judicial review.
I think the May in the regulation, it doesn't destroy finality because the regulations specifically provide that things become final if no review if no one seeks a further agency appeal. What the May does is it gives you an avenue to go to the agency so it can cure it.
But what if you don't? You can't go to court because it isn't final.
Well, I guess I would just characterize that differently perhaps and say you can't go to court because you haven't exhausted your administrative remedies. Even if it becomes final, it's the same thing as if where a district court judgment becomes final before a timely appeal is not taken to the Court of Appeals. In those circumstances, you can't then take an out-of-time appeal to the Court of Appeals on the ground that the district court judgment is now final. This May has the same effect as that. The agency action does become final if you don't do anything. That is, the agency is satisfied to put it into effect if no one has complained to the secretary.
But even though final, you can't get into court without exhausting your remedy.
That's right. And I think that is generally, that's always been true of applications of the exhaustion doctrine and actually numerous other doctrines. I mean, petitioner's argument basically is that because a statute, which in our view 704 sets a necessary condition for judicial review, because you meet that one necessary condition, which is finality, you thereby can get into court. That's a sufficient condition. And I think all of the Court's cases dealing with the whole range of doctrines that we discuss in our briefs stand for the proposition that even where you meet the statutory prerequisites for suit, those are the cases precisely where these doctrines apply and can govern the timing and availability of...
I had thought sometimes that where exhaustion applies, a court in which a suit was filed would just stay its hand until the administrative remedy is exhausted.
I think that would be in appropriate circumstances.
Except
that would be
for the time limit.
That's right. If there's no reason to do it, it might not, although I would add that HUD, perhaps in an appropriate case, could provide for an extension of the time limit. Thank you.
Thank you, Mr. Film. The Court notes from your admission papers that today is your birthday. You're 43 years old.
Thank you.
Happy birthday.
Thank you very much.
Mr. Gordon, you have 4 minutes remaining.
I'd like to address several points, if I may. The first is what I believe to be the absolutely erroneous contention that the government has advanced, that the decision of the Fourth Circuit here was consistent with the existing law of exhaustion. The law of exhaustion from the time of Myers v. Bethlehem Steel up through this Court's decision last term in McCarthy v. Madigan has always been that litigants are required to exhaust the prescribed administrative remedy. And that phrase prescribed is critical, and it has always been there. And in our view, all that Section 10C of the APA did was to ordain which remedies would be considered prescribed for purposes of judicial review. Moreover, the law had always been that litigants need not exhaust permissive administrative appeals. And Levers v. Anderson, decided by this Court a year before the APA was passed, Justice Black, writing for the Court, that precisely this contention was made. The government stood up and said that the litigant was out of luck because they hadn't pursued a permissive motion for reconsideration. And Justice Black said that the Court was not persuaded that may means must. And yet that's what we hear from the government today. May means must. And if you as a litigant, if you're sufficiently seasoned, if you can't figure that out, shame on you. That is nothing less than turning these administrative appeals into traps for the unwary, which was completely at odds with what Congress set out to do. I would note...
you know any cases, Mr. Gordon, in which the concept of finality was applied to failure to seek an appeal within the agency? Say it's not final because you failed to seek an appeal?
No, Justice Scalia, I do not, sir.
Yeah, I don't either.
I would also, on the facts here, the government has poo-pooed the notion that the LDP, which was in effect throughout, had much of an impact on Mr. Darby. The record reflects, and this is in an affidavit filed before the district court, that during the 10 months that he'd already been under these sanctions, he had lost a HUD contract that he anticipated would have been worth approximately $500,000 of profit to his business. So this is a litigant who diligently did everything that HUD told him to do, pursuant to its regulations. At the same time, he was enduring a tremendous cost for doing so. And the government suggests that there was little cost in him being required to jump through further hoops. If the additional 75 days for the secretarial appeal, and that's under an optimistic time frame, had gone by, the LDP could have expired because it's limited to a year. And according to the government and its pleadings before this court, once it expires, it becomes a moot issue because it doesn't have the continuing consequences that a debarment does. So the government pounds, in our view, nothing less than a catch-22 here. And we don't believe that the exhaustion doctrine is a catch-22 or should be construed by this court to place litigants in that position. If there are no questions from the court, that concludes my presentation.
Thank you, Mr. Gordon. The case is submitted.
Okay. So there you have the oral argument presented for Darby versus Cisneros, and it was wrapped around what they were battling, who was right about finality or exhaustion, and it really boils down to 34 of the Civil Resource Manual, and we'll go over that one last time for you as far as this video, and that's the exhaustion of administrative remedies. So think about things that you have going on in your life, around you and your family's lives, your friends, and see how such a requirement may be preventing you from actually receiving remedy. Not the requirement of the fact that you need to exhaust it, but the requirement of the fact that you need to know when it is actually exhausted, when you have actually done enough to satisfy exhaustion in life or in the chase or pursuit of happiness in that arena before you could take it to another level and find your remedy on a higher level. I'm Pasha Paroh. This is Y Net 7. Thank you for tuning.